On this week's FAS TV, we sit down with Linda Tinson and Lorna McKay, agricultural and rural business solicitors at Burness Paull. Both Linda and Lorna have a wealth of experience working directly with farming families, supporting them with succession planning. In this episode, they give us some practical considerations for your farming business and key things to consider as you approach your own solicitor for one-to-one advice.
Have a strong agricultural background in the team, and I'm a farmer's daughter originally and have been working in the industry pretty much all my career, and moved here in 2023 along with the team, and we look after, on the whole, farmers and estate owners and anyone who's got interest in rural business outside the 30-mile limit.
I joined along with Linda in 2023, and I've been working in rural business and agricultural law for most of my career as well. And I am also a farmer's daughter, originally from the West Coast, dairy farming. The day job is quite a mixed bag of acting for farmers, rural landowners of all types, and do quite a lot of agricultural tenancy work in particular.
A will is just what it says on the tin. It's a will. It's a wishes. It's a document that narrates your wishes. So when a person is considering their will, they should be considering who they would like their assets to go to on their death. Now, often wills are written a long time ago and they can be quite out of date by the time they're used, but they're still better than no will. That's the first thing I'll say. What we want to do is to put out the wishes of the person who's going to pass away, but it's very important that we know what they have before we write that will. If a will is written without consideration of what the assets are behind it, it sometimes can't be implemented. And that's why to just go to a will writer in the street is not generally going to work very well for a farming family. There's too many different competing interests, and we have other things to consider, like the partnership business, the possibly limited companies that have been formed over the years, the home of the people that are involved, and how they see it looking at the end and whether we can deliver that.
I think everyone should have a will at all stages of their life, and I think sometimes people get caught up in the day-to-day of life and don't prioritise that. And another thing that is overlooked is a power of attorney. A power of attorney is something you can call upon if you're not able to manage your own affairs. And people tend to think of it as, oh, well, I'm young and fit and healthy and that's not going to be an issue for me. But anyone can have a health issue, or they might just be overseas for any number of reasons. And there are two types. You can have welfare, you can have financial. And if you have a business interest of any kind, you really want to know that somebody can step in and look after your affairs if you're not able, for whatever reason might arise in the future. And it is simple things like, can someone else get into the bank account to actually pay out whatever needs to be paid out? You've got invoices falling due for a payment. Can someone sort that out? And I think that's overlooked at times, and it's such a simple thing. And the great spectrum of things that people come to us for, it's quite an easy one to tick off the list. Peace of mind, great, that one's done. So everyone should have a power of attorney. Most power of attorneys that we do cover both the welfare side of things, looking after your well-being if you're ill, and also the financial side. But you can separate them out and you can make them very bespoke. And often that's what we do, where it is purely the business interest that people are really worried about. And you can make it as limited or as broad as you wish. And if it is purely you want somebody to have access to the bank accounts to do administrative tasks, then it can be limited to that extent if needed. But it's a flexible tool and one that people can use quite readily.
So within a will, first thing to remember is, who are you appointing to look after your affairs on your death. So they're called executors or sometimes trustees, and it takes quite a lot of thought to think who would be appropriate to take on that role. Quite often we have people who are spouses who are appointed, but quite often it's advisable, especially with maybe a younger person, not to have a spouse appointed because it's a very stressful time. We're certainly not alone. So we would recommend that others of the same generation as the person writing the will as well, so it's not older people necessarily, are appointed as executors. You have to bear in mind that they will be the ones who have the responsibility of winding up the estate and making sure that the will is implemented. That's their first job. You can have a separate role of trustee if there's going to be younger beneficiaries given assets. So if you know that there's a grandchild or something who's going to inherit, for example, a farm, they may not be of age, which could be whatever age the testator decides, 21, 25, 30. And you've got to remember that the trustees for that person will have to know about the business, know how to run it, and they will be in a long-time commitment rather than a short-term executor role. You've then got to think, what do I actually want to happen? And you've got to then consider, do you want to make any specific bequests? So for example, quite often we have, I don't know, a personal number plate or a watch, something like that we want to specifically say. We have to be careful nowadays, specifically around tax and whether inheritance tax would be due on that bequest or whether it isn't, because we're now in a tax situation potentially. And then we have other bequests that are bigger, for example, your farming assets or your partnership interest or possibly shares in a company. We then get to the point you're looking at, right, what about the rest? And does the rest, all the sweep up of all the stuff you've got in your life, where does it go? And then you've got to consider beyond that, what happens if the people I've said are getting it are already gone? So you've got to think of the next thing, and then you've got to decide where do you go next with that? Is it going down a generation or across a generation, etc.? It sounds complicated, but most people have it in their brain already. They just need to express it. And then we get to the tidy ups. Now the tidy ups are key here because we've had a situation where farmers generally were tax exempt for inheritance tax. This is going to change in April. We have to now be very careful with everyone's wills. Probably needs reviewed in most cases now to check that it may say my farm to my son or daughter, to say whether or not that's subject to tax. So is that beneficiary going to have to pay the inheritance tax on receipt? Or is it going to fall to the general estate? The general estate being cash in bank and cars and so forth, which would normally maybe go to your spouse. So if the estate are bearing the tax, there may be nothing to go to the spouse in the end. So we do have to look at that as well and see what's intended. The other thing we sometimes have is what's called discretionary trust wills, which are basically appointing your executors to decide what happens when you go, usually made for tax planning reasons. And with that, a letter of wishes on the side, which will say, my preference is, but then you can replan it after death so that there's not a tax trap fallen into. So it sounds complicated, but if you get proper advice and you go through it carefully, it should be one of the more straightforward decisions you make. In our opinion, you really should be reviewing your will and power of attorney at any time there is a life event. The life event being something like a change in the asset base or a death of a near relative by which you have inherited, or possibly the birth of children or a spouse coming on board. It can be anything that is sufficiently major that you think, I may need to change my will.
We're often asked, how do I provide for my children, where some of them are involved in the farm business and some are not? And that is a perennial question which comes up. And there's no one-size-fits-all solution to that. Children will have a claim on their parents' estate. but the extent of that claim will depend on the nature of the assets held by the deceased parent and whether or not they are deemed heritable, which is land and property, or whether or not they are movable assets. Now, that on the face of it is relatively straightforward, except that things which are notionally heritable, such as farms, can sort of morph and jump into the movable pot if they are put into partnership, for example. So in all cases, we recommend that you have a good look at your situation so that you can assess what claims all of the siblings involved in the family have, and also have a think about whether or not you might want to make some changes. One thing that we come across a lot is making sure that people have looked closely at their accounts, because people don't always realise that the farm, which is held in an individual name on the public register, on the property register, is actually being held for the partnership, and that can change its status from heritable to movable and significantly changes the claims available to children on death. So it's a really big issue for a large amount of our client base. The difference between heritable and movable assets is kind of what it says on the tin. Heritable is land and property assets only, and movable is essentially everything else. It can be stocks and shares, cash in the bank, motor vehicles, interests in a business such as your partnership share. And that is why when property, which is heritable, which on the face of it sits in the heritable pot, if it is held for the partnership, can move into the movable pot, and it then becomes claimable under what's called legal rights on the death of somebody holding those assets.
The technical difference between the heritable and the movable once it gets to the partnership is that the property will appear on the balance sheet, but it's not really the property, it's the value attributed to the property. So the difference being that it's not actually the heritable title still held in my name, say, even though I've given it to use in the partnership and it's on the balance sheet, and therefore I've placed it in trust for the partnership. That is the value. So if somebody dies who's a partner in that partnership, the executor's duty is to pull out the value of that partnership share. The value of the partnership share is automatically movable, and that's where your legal rights kicks in. Mm-hmm. And the executors have an obligation to do that. If one of the beneficiaries who's inheriting a share of the deceased's estate is already a partner, then it would be, on paper, a paper exercise of that benefit going to the other partner. If, however, the beneficiary is not a partner, which quite often is the case, the other partners who survive have no obligation to bring that person in as a partner, but they do have an obligation to pay out to the executors of the deceased the amount that they'd be entitled to. And it's at that point the legal rights claim is made against the executory, and it's for them to recoup that from the partnership.
A partnership agreement is a contract between the individuals who want to go into business of farming together, which sets out the basis on which they're going to do that at its most simple, and crucially, who is entitled to the assets of the partnership should somebody leave the partnership or on somebody's death. And what we find is not necessarily well understood is if you don't have a partnership agreement, there is an automatic dissolution of that partnership on the death of any of the partners. And that applies even if there are more than two partners in the partnership. There is an automatic dissolution under the legislation. And that can be problematic in practical terms, because it can mean, for example, that banking arrangements don't operate because the partnership is at an end, strictly speaking. Banks are generally pretty helpful in working through these things, but at the time of a death in a family, these are not the kind of issues that we want to see families facing. So at its most basic level, that's one of the big protections of having a partnership agreement. Quite apart from all the succession planning and other good reasons for having a partnership agreement, that's up there as an essential.
When you're asked to join a partnership, the golden rule is to check the accounts. You're not only taking on the honour of being a partner in the business, which most young farmers are very keen to do. You take on the liabilities and the responsibilities of that partnership. So I always say to our younger, possibly younger, not always younger, new partners coming into businesses to make sure that they fully understand that this is joint and several liability for partnership affairs. And if you are coming in as a partner, you're inheriting the debt as well as the possible profit, and that you need to be clear and sure that that's something you want to do. And I think it's something that sometimes is overlooked in the excitement, and it's something people need to do. There are lots of different ways of structuring a partnership as well. Under the 1890 Act, which is our fallback if there is no agreement, it is a split equally kind of deal. However, with a good partnership agreement, you can make that bespoke. You can decide when you take on liability, what sort of liability. Have you got a capital share? Have you not got a capital share? Is it an income sharing only situation? Or are you accruing the income into your capital account? All of these things your accountant will be more than happy to explain, but also it's very important to then document it so it doesn't creep up. And that's for the existing partners as well as the incoming partner to consider. The general rule of thumb, and this is a general rule of thumb for farming businesses or any businesses, if you are gifted an asset or inherit an asset, it is yours. What becomes of it once it's yours may be that it becomes a matrimonial asset because you possibly put it into a joint bank account, because you possibly do something else with the money. You still would have a discussion around source of funds and where did that come from and was it intentional that went into that basket. But generally, in Scotland, very different from in England, it's not an automatic 50-50 split. And it is worth considering that protections can be put in place as well. We can have prenuptial arrangements. We can have postnuptial arrangements. If there is a genuine reticence to approach these things, but they can be done, and they can, in Scotland, hold a lot of weight. Again, in England, possibly less so. But we are not matrimonial specialists. We call in our team to deal with that. But there is a lot more protection than people anticipate. So a prenuptial arrangement or agreement is exactly that. It's before you get married. The parties would be separately represented. It's very important that they are separately legally represented and that they take separate advice. And that agreement will set out what happens in the event of a split. It will set out what assets each party has brought to the marriage and what happens with them and any accrual during that period. A postnuptial agreement is entered into after marriage, because quite often people don't get round to it before they get married. And quite often major life changes happen after they're married anyway, which would facilitate somebody thinking I should have one of these. And at that point, again, separate legal advice must be taken by each party, and then they can document what is intended with the assets at that point. Everything has to be agreed with full disclosure. If there's not, it's not good. So it's really key that it's one of these situations where a lawyer acting for the family is not going to be adequate. So that's one thing to remember. The good thing about a postnuptial or a prenuptial agreement is that the parties involved, other family members, can be comforted that we know what's going to happen. It may not be entirely one way, but at least they know what they can prepare for. Because I think the fear of the unknown is really more concerning to people than actually knowing what they need to set aside in the eventuality of something going wrong.
For agricultural tenants, there are particular considerations over those kinds of assets. And the tenancy is an asset. It might not always be thought of in those terms, but there are options available to leave that to someone in your will if you've made a decision on that. But it can be better for a lot of people, both for peace of mind and for other reasons, to look at an assignation of the tenancy during life. And that's something that we are seeing more of and certainly should be given consideration.
A major issue we face with tenancies is making sure they get to the next generation intact. This is for secure agricultural 1991 tenancies. And that is often the best advice, is to ensure that your successor is actually a successor in life. It makes sure there's no mistakes after death, that the time limits don't have to be adhered to in the same strict manner. And we make sure that the value of the tenancy is maintained by going to a younger generation. It gives the previous tenant peace of mind that is gone, and it makes sure that the family get the benefit of that farm going forward. There are quite a lot of people who are a bit reticent about it in deciding who that tenancy should go to in life. But likewise, we can write in minutes of agreement to back that up in the event that the tenancy is relinquished at a later date, or possibly another deal for financial gain to the tenant is made, whereby other family members could have some form of clawback on value if that's a concern. But it just goes to show that it's best to get advice. It is really quite a specialist area, and it's something that needs to be considered fully before you make a decision that can't be undone. Unfortunately for the man in the street, it is really important that an agricultural specialist advice is sought, particularly in relation to tenancies, but actually in relation to all things succession and all things farming, because it is a specific quirk of our industry that this is the lifeblood of the business that we can't afford to get wrong.
When families come to us looking to make a plan for the future, to make sure that the farm carries on for the next generation, they usually know roughly what they want. They don't necessarily know how it's going to be achieved. And although they know generally what they think they want, everybody has their own idea of what that looks like and where the ownership sits and who will be doing what down the road. So sometimes the starting point is making sure that everybody's being open about their expectations and their own plans for the future. You know, maybe son thinks that dad's planning to, sit back a wee bit and retire in the next 5 years, and dad's thinking, I have no intention whatsoever of doing that. So facilitating that conversation is the starting point, and trying to have an honest conversation is always a good starting point.
The most commonly misperceived perception is that a conversation has happened. There are words cast at the kitchen table or jumping off a tractor, but that is not the same as sitting and actually having a proper conversation. There is the perception that we've discussed it, and the reality is usually somewhat different. And so if we can bring in a catalyst to create that discussion, whether it's your bank manager, your accountant, your farm advisor, that is the way to get the ball rolling on the discussion. And actually set aside some time, make an agenda, treat it like a meeting. The kitchen table at breakfast time is not a meeting. Put a diary invitation in, get a meeting for the family set up and have it and note it. Because you're a business, you're not just a family.
It's those discussions about expectations, because they can wildly differ. And, we talk about the stereotype almost about, oh, when's dad going to retire? And sometimes it is entirely the other way around, where, there's an expectation that someone in the next generation is going to step up, and actually the next generation might think, I'm not sure I really want to do that. And that's a very difficult conversation to have.
And we're having some of them now. We are having some of them which have now been brought about by this inheritance tax situation, where clients of mine have gone away and had that family discussion with their children in their 40s, some of them, and they have come back to me saying, I don't know what to do, they don't want it.
For the generation that's looking to step back, there's a whole host of options, really, depending on what they want to do. Some of them want to, get off the tractor and run off to the golf course quickly. Others have no such plans. And for the businesses that are run in partnership, there's quite a lot of flexibility there about reducing their capital, reducing their control. The decision making in the partnership agreement can all be looked at. And as for the assets, the farm, if they are concerned about dealing with succession planning, they can look at passing on the farm to the next generation. All has to be looked at in the round, but absolutely have the conversation. There's lots of options. There's no, we must retire or we must carry on. There are plenty of middle ground avenues that can be taken. The position of tenant farmers has changed a little bit with the changes coming down the track on inheritance tax. All still in a bit of a state of flux. We're waiting on clarifications on whether or not the value of those tenancies will be caught under the inheritance tax rules. So in the first instance, it's back to basics really. Have a think about where do you want this tenancy to go when you are no longer looking to farm yourself. And probably that should be the driver for the conversation. The tax is important, but what's probably more important is what do you really want to do on the day-to-day. There are options for assigning during life. You can make bequests on death. That's something that has to be done very carefully because there's quite strict time limits, particularly where you're dealing with secure tenancies. But it's like so much of this succession planning in farming families, it's have the conversation, work out what you want to do and see if that's deliverable.
When we're looking at succession planning, one of the biggest hurdles we have is when people come to us with a plan, we quite often, when we start digging in the background, find that things are not quite as they seem. We quite often find that historic conveyancing hasn't been carried out, so that sometimes you'll find a title on the land register or not on the land register, on the old Saysian register. You'll find that possibly it's in the name of a grandfather even, and sometimes it's just never been formalised. We need to check. Quite often we'll find things are held in an individual name and then farmed by the partnership. Quite often we'll find they're in possibly joint names of husband and wife and farmed by the partnership, or in maybe two brothers or something like that. So it's very important we look at the backdrop. Unless we know what's in the asset basket, whether it's a tenancy, a title, ownership of the partnership, we have to get the full picture on all of that. And that comes from the official registers, but also comes from practice, from accounts. And we only can look at the whole succession plan if we have all that detail. Otherwise we're shooting in the dark. We can draft anything, but if it isn't fit for purpose because it can't be delivered, we can't deal with it. So back to basics, know what's in your asset basket, and then we can deal with it.
People usually ask, when should I start looking at this? And the answer is always now. Everyone should have thought about what their plan is for succession to their family assets and their business assets, and they should really be keeping it under review as well. And the changes that are afoot inheritance tax wise in the rural sector are affecting the rural sector are driving that. And on a positive note, it's making people think about it more. It's not been such an issue until now because for the most part rural businesses have a benefit from significant relief from tax. So while none of us are excited about the changes to inheritance tax, it at least is prompting some discussion and consideration, which is a great thing.
We deal with families all the time. The key message is seek advice. It's really not scary. We're quite happy to come and have a chat. And the key thing is to make sure you just don't put it back in the drawer. You get things done and we're here to help. And it's not something that's to be dreaded. I always consider it a bit like going to the dentist. Once you've been, it's better. So just keep pressing on.